Ms. April.
Yes, Your Honour. Good morning.
Good morning. I just can't see you. There you are. Thank you. I will just get the volume turned up, please. Thank you. Mr. Ansell.
Yes, Your Honour. I'm present. Hopefully you can see me on screen.
Thank you, Ms. Xu, if I've pronounced that correctly.
Yes, Your Honour.
Yes.
Thank you.
You're here, yes?
Yes, I'm here.
Thank you. All right. And is it Mr.? Is it Kuksal? Or is that how I pronounce it?
That's right, Your Honour. Good morning.
Good morning. All right. Thank you. So everyone is here? All right. So this is a case management hearing in the matter, which is a creditor's petition. And I'm just calling this so we can have some directions made about having the matter set down for hearing and filing of submissions. So I understand I've got the availability of counsel for the applicant or the creditor. Do any of the respondents have any views about hearing dates?
Your Honour, we have provided the court with 2 documents this morning. They are the constitutional notice and the interlocutory application that we had previously foreshadowed.
I don't have those. I don't know what you're talking about. Sorry, when you say provided the court, what do you mean? Filed?
I think Ms. Xu has initiated the filing of the documents in the registry, but it was also emailed to Your Honour's associate.
Well, I don't read emails to my associate. And I don't like documents being sent to my associate. So if you want to file something in the court, you've got to file it through the registry. All right. And if you want to communicate with my associate, then you will need to get the consent of the other side before you do that. All right. So.
But, Your Honour, the availability of the applicants was also conveyed via email to Your Honour's associate, I understand.
Availability, yes, but not new documents and other things. So anyway, do you have a view about the hearing dates for the creditor's petition? Are you available on the…
Yes.
Go on.
Your Honour, we're seeking for some preliminary matters to be determined before the listing of the creditor's petition, and those matters are the subject of the applications that were filed with the registry this morning. But they haven't been processed yet. They were previously foreshadowed to the court and the applicants. If Your Honour could obtain the document that was sent to the associate, it would be helpful in addressing the court.
All right, well, I will ask for that. I will just get it.
Thank you.
Your Honour, perhaps I could assist.
Okay.
I have a copy of the document in front of me, and my instructors have just provided it to me, so I've not had any time to consider it. It purports to be an interlocutory application seeking orders that my client be found in contempt of court, in relation to potentially someone giving evidence in this proceeding, and seeking leave for the issue of a subpoena to obtain documents as between my client and Gordon J.
I see.
And then, a constitutional notice, which I've not opened.
I see. I've got the application in front of me. What's the overlap between what's sought in this application and the creditor's petition? I'm trying to work it out.
So, Your Honour,
In my respectful submission, Your Honour, there is no overlap, and it ought not impede the listing of the creditor's petition being heard.
Your Honour, if I may address the court.
Yes.
The creditor's petition, firstly, is in relation to a matter that seeks… I'm not sure how much Your Honour is aware of the previous matters that were raised with the court.
Mr. Kuksal, there's 2 ways things can be raised with me. One is by filing an affidavit, another way is by filing written submissions, and the third way is by making submissions in the hearing. So I don't have the time or interest to read documents or emails that are sent through to the court. That's the way that proceedings are conducted. But I have regard to either evidence or submissions. And they're put on the record. So…
Your Honour, the respondents.
Go on.
The respondents have filed extensive affidavits in the proceeding. Nothing that was raised with Your Honour's chambers via email was different or separate from the evidentiary documents that have been lodged and sealed in this proceeding.
All right. Okay. Thank you.
What I was inquiring of Your Honour was whether Your Honour had had the opportunity to go through any of the documents that we had filed several weeks ago in this proceeding. And the documents that we filed in this proceeding are clarified.
What? Sorry, I missed that.
The first matter, there are documents that…
Okay. I understand you filed affidavits. And of course I will read those before the hearing, and I will have regard to them at the hearing. But I don't have to read them before…
Your Honour.
This is a case management hearing for the creditor's petition, so I'm trying to understand why.
This is the first listing of the matter because it's…
This is a case management hearing, where I'm inquiring about the parties' availability to list the matter and have submissions filed for the hearing of the creditor's petition. So the
reason why we are raising preliminary issues is comprehensively covered in the documents that we've lodged. But I will endeavour to summarise the issues. The first matter is that the costs orders that the bankruptcy notices were based on are unenforceable because they are irregular. They contain defects which make the orders unenforceable. One of the defects, for instance, is that the date of the order specified on the order is 1 year prior to the date on which the order was made.
All right, I understand.
So the orders are defective.
I'm just looking at your application though. In your application, the things that you are talking about have no bearing on the things that you are seeking in the application. So what you're doing now is you are referring to things that are in your affidavit that you will say is a basis for me not to make a sequestration order. That has got nothing to do with, for example, saying that Cause Westgarth Chambers are in contempt.
Okay, so if I may, just starting with the first matter first.
No, well, let's go through the preliminary matters and how they're dealt with in your affidavits. These are the things in your application.
Okay, so Your Honor, the applicants have failed to address any of the issues on which we contend that the creditor's petition could not have been lawfully lodged, one of those issues being that we had applied to the court on time to set aside the bankruptcy notices, and our applications were improperly rejected after we have been given assurance that our applications would be sealed on time. That matter is currently before the ART. We're seeking a review of the registrar's decision to refuse the acceptance of the applications we have made to set aside the bankruptcy notices. What we contend is that the current proceeding has been commenced as an abuse of the court process. And we had, on the 15th of May or prior to that, sought to bring an application that would have sought to adduce evidence against the applicants regarding their persistent abuse of the court process, to essentially oppress their opponents in the court proceedings. The applicants then sought to exert improper pressure on one of the witnesses that we were going to rely on, and that we had put the applicants on notice that we were going to rely on. And it is because of their interference in that process that the contempt of court matter arises. That's the first round upon which the contempt of court matter arises. Now, Rule 44.01 of the Federal Court Rules stipulates that any application seeking contempt of court in relation to matters that arose within the proceedings has to be made as an interlocutory application. And it is prudent that the court determine the matter of the interference in the presentation of our applications before the court goes on to determine the entirety of the proceeding. That's the first matter upon which the contempt application, or that's the first basis for the contempt charge against the first applicant. The second basis is that when the first action that gave rise to the contempt charge did not yield the results that the first applicant had hoped, the first applicant then made a separate application to commence a different proceeding in the federal court, the purpose of which was to admittedly prevent the respondents from relying on the evidence that they had sought to rely on in the bankruptcy proceeding. And that, we say, is the ground for a second contempt charge against the first applicant, because they are seeking to prevent us from adducing evidence regarding the improper purpose for which these proceedings have been commenced. So those applications must be determined by the court before the court progresses on to the hearing of the creditor's petition. The third matter that's raised in the creditor's petition is that, as Your Honor would be familiar, the orders that are the subject of the bankruptcy notice are not automatically proof that the respondents owed money to the applicants. They are simply a relevant consideration for the court. And where the respondents raise allegations of collusion or fraud, and where they are raised in a manner that is legally arguable, then the federal court is obliged to inquire, go behind the judgment, essentially, or give the respondents an opportunity to adduce evidence about the fact that, well, there are a number of grounds that they can rely on then. Collusion is obviously one ground. The other ground is the denial of fair and public hearing according to the law. I will cite the leading authority in this matter is obviously Ramsey v. I'm just going to bring up the citation.
I'm familiar with the authorities about going behind the judgment. Thank you.
Okay. So we're saying that the court should go behind the judgment. That's the first matter. The second matter is that in the event that the cost orders were made after Gorton J. was disqualified from hearing the matter on account of His Honor's improper communication with the respondents, the applicants, then, essentially, we say that the evaluated judgment that the court has to perform in order to decide whether or not it will enforce the purported orders, we say that it does not permit the court to enforce the cost of this, because the orders were made in breach of the right to a fair hearing. We've also provided a copy of a recent transcript of a hearing that took place in the High Court, in which very similar matters arose. Essentially, following the conclusion of proceedings in the federal court, in a tribunal, and the appeal proceeding in the full court, the applicant in that particular matter discovered that there had been improper communication between the judicial officer presiding over the matter and the statutory body against whom that particular applicant had sought judicial review. And in fact they discovered the existence of this correspondence after their appeal to the High Court had also been dismissed. They then commenced a judicial review proceeding in the High Court on the basis of the new evidence, which, incidentally, was obtained also through the making of an FOI application, and the respondent in that proceeding, the way they responded to the FOI application, which is the same as what has happened in this particular matter. And the High Court Justice Stuart J., who presided over the hearing of that matter, effectively made statements to the effect that the law, the common law, as it applies to the exercise of judicial functions and the obligations of modern litigants, would necessitate that the body that was seeking to maintain the order clarify to the private litigants whether or not there in fact have been any private correspondence or any relevant correspondence between the judicial officer and the statutory body. Those were the views of Stuart J., as they are caught in the transcript, which was shared with the court earlier through the same email through which the application was shared. So we say that, based on what was said by Stuart J., but also based on our right to a fair hearing, and we rely on Department of Housing v. Sudi, SUDI, in which the Court of Appeal of Victoria clarified that access to disclosure of relevant material is a necessary component of the right to a fair hearing. So we say that in order for us to get a fair hearing even in this particular proceeding before the federal court, we are entitled to getting access to the documents that we're seeking through the subpoena. The documents are sought in relation to a matter that has the possibility of definitively quelling a serious controversy that would otherwise bring the administration of justice into disrepute. And we say that the evaluative judgment that the court has to perform precludes the possibility that the court proceeds with the determination of the creditor's petition without giving us an opportunity to have that correspondence disclosed. If that correspondence in fact exists, it conclusively disqualifies Gorton J. at a time that precedes any, that is prior to any of the orders that Gorton J. had made, which are sought to be enforced improperly through the issuing of the bankruptcy notices. So that's how the preliminary issues connect with the hearing of the petition. And we say that we cannot get a fair hearing based on the right that we have pursuant to Section 24 more of the Charter of Human Rights and Responsibilities, and the equivalent provision of the International Covenant on Civil and Political Rights. And I can cite various authorities that sample the proposition that those rights necessarily require equality of arms between the parties, and that necessarily requires symmetry of relevant information.
All right, thank you. Ms. April, would you be able to respond to that, any of that?
Your Honor, I admit it was, with all due respect to my friend, difficult to follow, but I will make a couple of points in response. First, this interlocutory application, it has not been filed, it's not actually before Your Honor, it purports to be brought against Mr. Heath. He is not a party to this proceeding.
Sorry, where do I see that?
In my respectful.
Okay, interlocutory application. I might mark this for identification, just so that we have something on the record that we know what we're talking about. But the court find that the first, are you looking at the same thing as me?
Yes, I am.
So one is the court find that the first applicant acted in contempt. So how is that? Who is that brought against, do you say? I see.
My understanding is that is brought against my client, the board. And then if Your Honor looks to paragraph 2 there,
yes, I see.
The applicant's solicitors and Mr. Heath acted in contempt of court.
Yes.
And then there's reference to Gorton J. of the Supreme Court of Victoria. Your Honor, in my respectful submission, if the respondents wish to ask the court to look behind the judgments upon which the bankruptcy notice was based, that is a matter that can be dealt with, Your Honor, at trial. Second, orders were made by Meager J. on the 21st of May 2025. They were suppression and non-publication orders in relation to the material that the respondents wished to lead as evidence in this proceeding. It is incorrect, in my respectful submission, to say that that proceeding was brought to prevent them from relying upon the evidence in this proceeding. There is a question of whether that evidence is in fact admissible in this proceeding. And that is a question that Your Honor can deal with at trial. It's not necessary that it be hived off, and it ought not hold up the hearing of the creditor's petition. I am instructed, and I should say, Your Honor, I am standing in for Mr. Silver, who is trial counsel in this matter, so you will not see me at the ultimate hearing.
Yes.
But I am instructed that a proceeding has been issued in the ART, and that is listed for directions on the 28th of August. I'm instructed that there is a jurisdictional question, and that my client will be submitting that the ART simply has no jurisdiction in relation to that matter. And therefore, in my respectful submission, it ought not hold up the hearing of this petition. The interlocutory application that the respondents purport to rely upon, in my respectful submission, it is baseless. There are no grounds to bring that application. And it is being brought for an improper purpose that is simply to derail the hearing of the petition, Your Honor. As for the issue of subpoenas, I'm instructed that the respondents sought an order that they be permitted to issue subpoenas in this proceeding before Judicial Registrar-Ellis. Judicial Registrar-Ellis refused that application.
That's,
In my respectful submission that,
Your Honor, that's,
Excuse me, Mr. Kuksal, may I continue my...
you're making a factual assertion.
No. Miss April can make her submissions and then you can respond. Alright, you don't interrupt.
But that's a factual.
Thank you, Your Honor. And in my respectful submission, the decision that was made by the Judicial Registrar ought stand. There is no fresh evidence that the documents that will be obtained will assist the court in the hearing of a petition in any way, shape or form. And the Judicial Registrar's decision ought stand.
Alright.
Your Honor, may I quickly address the applicant's solicitor, or counsel, sorry.
So what are you going to do?
I would like to respond to some of the assertions.
Well, I will just make sure Ms. April is finished. Ms. April, did you have anything else you wanted to add?
I don't, Your Honor, the point.
Well, I was just looking at this proceeding 642 of 2025. Can that be combined with this proceeding?
Yes.
And then, the two can be dealt with at the same time.
Well, I don't know if they can, Your Honor.
Okay.
They don't really overlap. 642 was the proceeding that was brought to prevent the dissemination and publication of the what I would call the Flitner material. Other than the fact that it was born out of this proceeding, it really has no relevance to the hearing of petition. As I say, the respondents wish to rely upon that material as evidence in this proceeding. There's a question as to whether it's as tenancy evidence.
I see.
There's a question as to whether that evidence would be admissible.
I see.
It's simply a question that can be dealt with by Your Honor at the trial of this proceeding. And 642, there are interim orders that have been made. And it needs to be listed for a final hearing, for a final permanent injunction.
I see. Alright, well we will come back to that.
In my submission that, yes.
Your Honor, if I could quickly address some of the misleading assertions that have been made. Firstly, Your Honor, Mr. Heath is the applicant's solicitor. We do not need to add him to the proceeding to seek orders against him. I can cite several authorities in support of that proposition, but I will cite one. This is Harnett v. Bell, 2023, NSWCA 244. Bolitho v. Banksia, 2020, VSC 666, also affirms all those principles that have been set out in Hartnett v. Bell. We do not need to add Mr. Heath to invoke the court's supervisory jurisdiction in respect of the conduct of its officers. Just like you do not need to add a solicitor to a proceeding to seek costs orders against them, or orders in addition.
I get the point. I understand the submission. What's the next submission?
The next submission is that there were multiple things that were wrong with the assertion, that the subpoena application has been conclusively decided by Judicial Registrar-Ellis, and we say that that submission could not have been made in good faith. Firstly, the respondents have a right to have the matters heard as a de novo hearing before Your Honor. It's irrelevant whatever Judicial Registrar-Ellis would have decided or not decided. We have a constitutional right that we access the source of the judicial power in these proceedings. Judicial Registrar-Ellis was exercising a delegated role, and we have, in effect, caused her jurisdiction to come to an end when we requested Her Honor to refer the matter to a judge. So Your Honor does not even need to consider whether or not the matter was even contemplated by Judicial Registrar-Ellis. Secondly, Her Honor had not decided the matter. In fact, she had invited the application. This is a matter of the record, because it's caught in the transcript of the proceeding. What had happened is Her Honor had instructed the respondents to write to her chambers with a draft of the subpoena that was to be issued. The respondents had alleged that, based on Her Honor's initial reaction to the proposed subpoena, an apprehension arose that Her Honor would not receive the subpoena with an open mind, and that it could be said, or a reasonable apprehension arose, that she had prejudged the matter. But as a matter of fact, and as a matter of the court's record, Junior Ellis had requested, or instructed rather, the respondents to make the subpoena application to her chambers. So it's completely, I note that making the assertion was in breach of the barrister conduct rules because it was made in relation to a factual.
And you?
Your Honor,
Your Honor, I will not be interrupted at this time, just like men's.
This doesn't help. Can I just say, this doesn't help. Personal attacks.
Lied to.
Personal attacks on the other barrister on the other side doesn't help your cause.
Your Honor, I haven't.
The submission was made that Judicial Registrar-Ellis dealt with this. You've responded and said that doesn't matter because we can have a judge hear it. That's the answer. And you don't have to then go on and make personal attacks on the other barrister.
I have a right to make a complaint to the court.
No, no.
Your Honor could not.
Not at large. This is not a commission of inquiry. This is a case.
But Your Honor can hear.
This is a case management hearing for the setting down of a creditor's petition, and you
Your Honor,
are making submissions as to why I should predetermine some issues before we have that hearing. That's it.
Your Honor,
And I don't have all day.
I would like to complete what I'm saying, and then Your Honor can determine whether or not it was said improperly. I note that if Ms. April had first checked the transcript before making an assertion about
No, I'm going to
matters,
I'm going to stop you there. I'm not interested in a submission against the other counsel. All right. So can you continue on to respond to things of matter of fact or law in response to the submissions that were made?
Your Honor, the respondents take objection to Your Honor's position in that respect. I will continue as Your Honor is directing, but
Thank you.
we resile to raise the matter at a later stage. Now, in relation to the matters that we were previously addressing, we have a right to issue the subpoena, as in relation to the material that the respondents wish to lead as a party in this proceeding. Whether or not the court ultimately determines that the subpoena will help is an evaluative judgment that the court has to perform. Section 192 of the Evidence Act is the basis upon which that evaluative judgment is performed. I have authority which we have referred to in our previously filed submissions in this proceeding, submissions which have been sealed, that set out the manner in which the court is obliged to make evaluative judgments that are covered by the provisions of the Evidence Act. So whether or not the evidence would be relevant to this proceeding is decided by Sections 55 and 56 of the Evidence Act, in terms of admissibility. If the evidence would be admissible in this proceeding, then the next question is whether any exclusionary criteria should be relevant. They have not identified any exclusionary criteria. The evidence is of such a nature that we say it also touches upon our right to a fair hearing pursuant to Section 24 of the Charter of Human Rights and Responsibilities. I've already cited an authority in support of that proposition, but I will give the citation fully right now, just so there are no ambiguities about this matter. So this is the Director of Housing v. SUDI, SUDI, 2011, VSCA 266. In this particular matter, the court had covered quite extensively what the right to a fair and public hearing entails. I also refer the court to the authority of Rag v. Magistrates Court of Victoria, 2008, VSC 1. Again, that authority touches upon the right to a fair hearing and what's involved in that, where.
All right, I understand the submission. So your submission is that you want these preliminary matters. Just so you understand, this is a case management hearing. They normally go for about half an hour. So I want you to respond to anything that Ms. April said, in reply. All right. Now what do you want to say in reply?
Okay, with respect, Your Honor, what Ms. April has asked Your Honor to do is make a substantive decision. She's effectively asking Your Honor to summarily dismiss our application, and
No, she's not.
And
I'm not going to do that.
yes,
I'm not going to do that, so you don't have to worry about that.
Okay, so Your Honor, let me then say this. If the objection or the opposition to the application is simply on the grounds that it has not yet been sealed, then the application is an irregularity and not a nullity. The court still has to exercise its discretion before it determines that the application is not available for Your Honor decision-making right now, and I can cite authority in support of that proposition.
But just so you understand, I'm not actually dealing with the application right now. Just so you understand that. Because the application hasn't actually been filed yet. You said to me, look, we've provided an application, my associate got it a few minutes ago, she has forwarded it to me, it's sitting on my screen, but I'm not actually dealing with this application right now. What I'm dealing with is a case management hearing for a creditor's petition that has been filed, and you've provided a document at the last minute that seeks a vast array of things, such as wanting me to deal with issues identified in a constitutional notice that I haven't seen, before I then go on to deal with the creditor's petition. So to be
But, Your Honor,
fair to Ms. April, she hasn't had the opportunity to look at what you're seeking and make proper submissions about what you're seeking. I'm not dealing with the application right now.
in that case, Your Honor, we seek an adjournment, and we rely on the authority that the court's proper exercise of the evaluative judgment that should be made in this matter precludes the possibility that the court prevent the listing and the hearing of the application. Given that, as a matter of law, Your Honor, the application, because it is before Your Honor, it is not a nullity. It's not that the application doesn't exist, it's an irregularity, and I will cite authority in support of that. So there's McFoy, MACFOY, v. United Africa,
I don't think you understand what I'm saying. I'm not saying it's an irregularity or a nullity or a problem. What I'm saying to you is I'm not dealing with it right now. Okay? So you're saying to me,
But that's...
no, your submission is, don't set the creditor's petition down because I want you to deal with these other things before you hear the creditor's petition. Am I right? Okay.
That's right. Your Honor.
I'm not saying anything about the application. I'm just listening to your submission to say, don't set the creditor's petition down. All right? Ms. April has said some things about it and said, no. Basically, go ahead and hear the creditor's petition. But what I think I should do, having listened to you, is ask for submissions from both sides in writing, limited to 10 pages, as to why I should deal with any of the things in this application before I set the creditor's petition down.
Your Honor, it is not simply a matter of...
Your Honor.
Yes.
Sorry, Your Honor, I was still speaking. We say that it is not simply a matter of submissions. It is a matter that must be heard in open court, because there are evidentiary matters that must be addressed, so the thresholds are met. Relevantly, the matters that are asserted in the constitutional notice are matters of fact.
Just so you understand, I'm not saying the application won't be heard in open court. I want you to make submissions as to why I should deal with the application in open court before the hearing of the creditor's petition. Does that make sense?
Let me just clarify one thing. In determining that threshold issue of whether or not it is prudent to consider that application beforehand, I accept that it can be heard simply on legal submissions. But in hearing that application then, the presumption is that the evidence that we purport to rely upon is taken at face value, or the application is decided, as if we had the evidence that we were purporting to rely on, when the court is simply determining the matter of legal fact. So what I'm saying is that...
I don't know what you mean. I'm not going to give you legal advice. And there's no presumption that I'm aware of that applies.
Let me clarify what I'm saying. What I'm saying is that the respondent's concern is that when the court schedules a preliminary determination on the papers based on the legal submissions, the applicants will state that there is no evidentiary basis upon which the matters of law that are argued can possibly be argued.
Well, they might.
That's a double jeopardy to us. Sorry?
I said they might, I don't know.
So then, we must be given an opportunity to present evidence to counter that submission. Because that's, whether or not there is evidence, is a matter that can only be decided after the court considers the evidence. So if the objection will simply be based on the fact that there can be no evidence, or the respondents do not have evidence, that, when I say there can be no evidence, not as a matter of law, but as a matter of the fact of the circumstances, if the applicant's objection to our application is simply going to be that there is insufficient evidence, then, the court must actually give us an opportunity to adduce the evidence that we will rely on and make submissions about the sufficiency of the evidence. But apart from that, we're happy to address the court via submissions. We say each of us should be given an opportunity to file independent submissions. We accept the 10-page limit that the court is proposing, but we should be given an opportunity to produce evidence in case the court decides to determine the objection about the sufficiency of the evidence.
Ms. April?
Your Honor, if I might respond. I've heard what Your Honor says about the submissions.
It's just an idea.
It does appear to be a prudent course. However, I do note that while the application is in front of Your Honor, it is not before Your Honor. It has not been filed there. I have not seen an affidavit in support. And this matter is really dragging on. So if Your Honor is minded to order that the parties put on submissions, could I respectfully request a tight timetable, and that the submissions be limited to 5 pages? Simply does not need 10 pages. We're just wasting the court's time and the parties' time and resources.
I understand. All right.
Your Honor, heard about that.
Yes.
Does Your Honor require me to address the need for 10 pages and not 5?
Why do you need 10 pages?
Well, Your Honor, you have initially indicated 10 pages.
Yes. That was just an idea. I was throwing it out there.
Well, Your Honor, it's a basis upon saying 5 pages presumes the limitation of the grounds. And we say that if Your Honor were to limit, that would give rise to a reasonable apprehension that Your Honor has formed some views about the range of grounds that can be raised. There is no prejudice that arises from the parties having, being required to consider 5 additional pages. We will possibly.
You're not making submissions about the grounds. All you're making submissions about is why these need to be dealt with before the hearing of the creditor's petition.
Those are.
So contrary to what you've just submitted, if I limited you to 5 pages, that would not be a reasonable apprehension of bias, which is, I think, what you're about to say.
What I'm saying is that 5 pages is an arbitrary limit, and in making that order, after Your Honor initially indicated 10 pages, and we have accepted that, Your Honor would be making that judgment based on some apprehension of the range of legal arguments that can be raised in support of the contention that we're advancing. We're saying 5 pages is not sufficient. Ms. April's argument is that the matter is such that it cannot be reasonably covered by submissions as comprehensive as would require 10 pages. We're saying that whether it is or it isn't is the question of fact in this matter, that the court can only consider after giving some thought to the possible grounds that can be raised, the legal grounds that is, in support of the fact that our application should be heard before the creditor's petition. So we say that 5 pages does not add to any material extent to the court's workload or the applicant's workload, and it would only lead to further controversies in this proceeding.
I'm giving you 10 pages. All right.
Thank you.
I'm also listing the creditor's petition for 28 and the 29th of July. And if I form the view based on the submissions that there needs to be a hearing of the other application before 28 and the 29th of July, which is 6 weeks away, then I will do that.
Your Honor, I want to be heard about that. If the court were to preemptively make that decision, then it would give rise to a reasonable apprehension that Your Honor has already decided.
Sorry, what preemptive decision am I taking? Today was listed for the purposes of listing the creditor's petition for hearing. I'm doing that. It's 6 weeks away. Now if I decide based on your documents that your allocation should be heard first, I will hear it first. That will happen before the creditor's petition.
Your Honor. Okay. But the fact of the matter is that Your Honor became aware of our application. And we say that. So we have the right, according to the rules, to seek leave to basically file this application or raise this application orally. The fact that the application has not been sealed is not relevant at all in relation to the court's consideration of the application. And I can cite multiple authorities about that. Now I also rely on Minister of Immigration and Citizenship versus Li, L.I., 2013, HCA 18. If the court takes the steps that the court is foreshadowing, then the court would have necessarily made some representations that are capable of raising a reasonable apprehension of bias or prejudgment about whether or not our application is likely to succeed. There is no reason, if the court were just as convinced that our application would succeed as it was that it may not, then it does not make any sense for the court to, in a completely uncertain position, lists that matter. The listing of the matter necessarily implies that Your Honor is placing a higher threshold on the respondent's application, and it may be because Your Honor feels that it was filed late. We have not been heard about why it was filed late, or whether or not it was reasonable for us to file it earlier. We would like to be heard about that. But in any event, whether or not the court should hear this application and openly consider it before the listing of the creditor's petition is necessarily a matter that Your Honor needs to decide on the basis of the contentions that are raised in that application. I also note that Your Honor, it would seem, is unaware of the threshold arguments that we have raised about the court's jurisdiction in this proceeding. And I refer Your Honor to the authority of R. V. Gray, ex parte Marsh, in support of this proposition. The citation is 1985, 157, CLR 352. The basic principle is this. When the jurisdiction of the federal court is involved in any matter, the preliminary jurisdiction that is involved is a jurisdiction to inquire whether the substantive jurisdiction exists. In this matter, the first jurisdiction that is involved is for the court to see whether the creditor's petition can be listed. We have raised preliminary issues that assert that the creditor's petition cannot be lawfully listed, because it is brought contrary to the law, and it is brought as a perversion of the course of justice. The court must hear and determine that before listing the application, because the court would then be preemptively exercising a jurisdiction that the court cannot exercise before determining that it has that jurisdiction. And there were extensive arguments that were made in this respect by Justice. Not arguments so much, but the law was clarified by Brennan J. R. V. Gray, ex parte Marsh, in that respect. I also note that the Judiciary Act actually precludes the court from continuing to hear a matter once a constitutional notice is filed, before the Attorney General has had an opportunity to intervene. The exception to that proposition is if the court determines that the matters that are raised in the Constitution notice are actually not matters that raise constitutional issues. So Your Honor cannot, as a matter of law, list the application after we have a right to file the constitutional notice. We do not need the court's leave. Once we file the Constitution notice, by simply emailing the court as a matter of law, we have filed those documents. Those are the federal court rules. So the document has been filed. There is no further qualification or selection criteria in relation to the filing of the constitutional notice. The only way in which Your Honour can take further steps in the proceeding without giving the Attorney General an opportunity to address the matters raised or seek leave to address the Court about the matters raised in the constitutional notice, is if the Court determines that those matters do not raise any constitutional issues as a matter of law.
I'm going to have to stop you there, because I have to actually get on to other matters. So the orders that I will make today, first of all, I've made your draft application. I've marked it for Identification 1, MFI 1. And so even though it's not filed yet, it's on the file now not as an exhibit but as a document that's marked MFI 1. And so the first order I will make is that parties file and serve written submissions, limited to 10 pages, addressing the issue as to whether it is necessary to hear and determine the application which is MFI 1, before the hearing of the creditor's petition. 2. The creditor's petition is listed for hearing at 9:30 a.m. on 28 and the 29th of July 2025 in Melbourne. I note, this is not part of the order, but I note that in the event that I am persuaded that the interlocutory application should be heard and determined before, rather than at the same time as the creditor's petition, then that may lead to an adjournment of the creditor's petition. But at the moment, it is listed for hearing on 28 and the 29th of July. Adjourn the court, please.